Hello, I'm Timothy Wiseman of Ocampo Wiseman Law, formerly Morris Law Center. Today we'll be going over a brief overview of the process of civil appeals from a Nevada District Court. Before we get into the heart of the matter, there are a few caveats. This is only an overview of the process. We will not be getting into unusual situations, such as honeycut remands. We will not be discussing all the exceptions or all possibilities that could occur. Also, the focus here is on civil appeals from the Nevada State District Courts. The federal courts have a slightly different process, and the process for appealing from a small claims judgment is substantially different. The rules do change occasionally, but this information should be current as of the time this video is being recorded on January 1st of 2023. As always, nothing in this video constitutes legal advice, and if you have specific questions, you should consult with qualified counsel. Speaking of qualified attorneys, when considering an appeal, one of the first questions you should consider is whether you need specific appellate counsel. Many litigators are also skilled appellate counsel, so you may be able to proceed with the same attorney. However, many litigators are not experienced in the appellate process and prefer to instead either retain appellate counsel to assist them or refer the client to specific appellate counsel. One of the first parts of an appeal is determining whether you have an appealable order. In other words, whether you can file an appeal in the first place. This is primarily governed by INRAP, or the Nevada Rules of Appellate Procedure 3A. Usually an appeal is taken from a final order. That is either an order which addresses all issues in the case and resolves all matters which are before the district court prior to an appeal, or an order which resolves certain substantive matters and is certified as final for purposes of appeal. There are, however, certain other types of certain appeals that can be taken from other orders that are listed in INRAP 3A. Additionally, there are certain types of appeals that are specifically authorized by statute, such as an appeal from a denial of an anti-SLAPP motion. Once it's determined that an order is appealable, the next step is to determine how long is available to appeal. And that depends slightly on the type of order and if there is a governing statute. However, pursuant to INRAP 4, it is normally 30 days. In Nevada, the deadline to appeal is almost always considered jurisdictional. This essentially means that it cannot be extended, and that if an appeal is untimely or filed late, then it will be automatically dismissed, and the Nevada Supreme Court or the Court of Appeals will determine they do not even have jurisdiction to consider the appeal. However, there are some nuances to this. For instance, the time to appeal will not run while certain motions are pending if those motions are timely filed. For instance, if there is a motion for a new trial under NRCP 59 that is currently pending, the time for the appeal will not run until that motion is resolved. As always, this can be a slightly tricky area with more nuance than it may appear, so if there are questions, you should consult qualified, experienced appellate counsel. Under normal circumstances, the first formal steps of an appeal are filing the notice of appeal and the case appeal statement. These are both using standardized forms, and they are filed in the district court, not with the Nevada Supreme Court. Usually, the filing fee and the cost bond will be paid at the same time the notice of appeal is filed. Under some circumstances, especially if a defendant who has had a monetary judgment awarded against them is filing, it may also be beneficial to file a supersedious bond or other bond required to initiate a stay. Frequently, shortly after an appeal is formally initiated, it will be diverted to the settlement conference program. This program is governed primarily by INRAP 16. This settlement program attempts to help the parties reach a settlement rather than having the matter go through the often lengthy and expensive process of a full appeal. It is frequently, though obviously not always, successful. Usually, when the matter is diverted into the settlement conference program, most other deadlines will be suspended, though the deadline to file a docketing statement is often not suspended. Early in the appellate process, the appellant must provide Notice of transcript requests on transcript request form to the Nevada Supreme Court. The appellant must also provide a docketing statement. The docketing statement assists the court in identifying jurisdictional defects, issues on appeal, assessing assignment to the Nevada Supreme Court or Court of Appeals, scheduling oral arguments, and determining if expedited treatment is appropriate. It can also be used for compiling statistical information. The briefing and appendix are the heart of most appeals. They are governed by a variety of rules, but primarily by INRAP 28, 30, and 32. Generally, the appellant will provide the appendix after consulting with the respondent. The appendix provides essentially a record of what happened before the district court. The appellant then files the appellant's opening brief. This provides the appellant's argument and explains why the appellant believes they should prevail on appeal. The respondent will then file a respondent's answering brief, which addresses the appellant's opening brief and generally is usually used to explain why the appellant should not prevail on the appeal. The appellant may optionally file an appellant's reply brief. This is not required, however, it is used in almost all cases where an answering brief was filed. There are unusual circumstances where additional briefing is permitted, but that is uncommon. Generally, those are the only briefings that are allowed. In Nevada, most appeals are decided without oral arguments. That is, they're decided entirely based on the written briefs that were provided. However, the Nevada Supreme Court or the Court of Appeals may allow oral arguments in some cases. The decision after the arguments, if they're allowed, will be issued in a written form, and that will normally resolve the appeal. There are some circumstances where further request for review may be made even after the appellate court issues a decision, but those are well beyond the scope of this video. As always, if you have any questions, you should consult with qualified counsel. Thank you and have a great day.